Evening, everybody. Good evening. I will share my screen with your permission here. And the presentation that I have here is just to start us, not necessarily to go over every slide. Now, you experienced something that every parent with a disabled child experienced sooner or later. Children receive SSI benefits, and you probably all know why, because under age 18, Social Security counts income and resources of a family to determine whether the child is eligible for SSI. And there are a lot of rules. So frequently, you would see a child who is disabled and may meet the disability standard under the Social Security rules, but doesn't qualify for SSI because part of parental income and assets are countable. At age 18, and that's probably what you've seen if you are planning transition from school into adulthood, into the community living, they are eligible for SSI. And some of them engage in work and some of them don't. And if you have a child, a young adult who has been working part-time, that person probably slowly became eligible to another benefit under another program, SSDI, Social Security Disability Insurance. Another name is Title II of the Social Security Act. And you went through a very similar exercise to the one that we will discuss tonight. The child was transitioned from SSI into the SSDI world and was eligible for SSDI benefit based on his own wage record because the child was working. Sometimes children like that receive both SSI and SSDI. Now, another less expected way to come to a very similar situation is for a child to receive SSI and have a parent who is approaching retirement age or who is now entitled to disability benefits, himself or herself. Unfortunately, parents and children in this situation don't have a lot of choice because SSI program is considered to be a program of last resort. So if a child is eligible, if an individual is eligible on any other record to any other benefit other than SSI, such individual is mandated, obligated to explore the possibility of entitlement. So frequently, when parents are consulting with SSA, be it by phone or they make an attempt to file online or maybe come in person, an experienced Social Security representative will inevitably ask if there are any dependents, and if there are dependents who are not minor, whether they have disability. If you encounter somebody who's less experienced, sooner or later, Social Security will pick up on the idea that an SSI eligible disabled individual is now potentially eligible on the record of a parent, and they will probably send you a letter. So you will encounter it either by initiating a retirement application on your own, or you eventually will receive a letter from SSA where they will say you have to explore other benefits, and we would like to see if you might be eligible for the to an SSDI benefit on the parental record. So analytically, what you have to understand is that the only connection to you in this situation is your record. Your lifetime wages paid into the Social Security fund earned you retirement or disability benefits. And now when Social Security will calculate how much your child can get, they will look on your record and they will pay 50% if you are disabled, if you receive disability benefits, or 75% if there's one parent who is deceased on a record of a deceased parent. And that's pretty much the connection. Everything else in terms of what the child is eligible for, what happens with Medicare, what rules apply about work. All of these rules, they're no different from those who receive SSDI on their own record. So I think there's a lot of confusion, primarily because Social Security calls this benefit child's benefit, CDB, DAC benefit. So you hear all these letters, but you can't understand what they mean. So primarily tonight, we will be talking briefly about what Social Security calls child's benefit, or CDB, childhood disability benefit, or sometimes they call DAC, disabled adult child benefit. So the mechanisms I just explained would be the child is disabled, disability is established, and the child is receiving benefits on the record of the parent. So let's start first with the retirement. Let's say you are facing a situation for yourself. You are trying to understand what is going on with your planning. And your first question, do I retire at 62? This is early retirement. Do I retire at my full retirement age? Or do I retire at age 70? You are planning it based not on what you think about the child necessarily, you have to decide for yourself. And when you are entitled to the SSDI benefit or retirement benefit, then there is an exploration whether your child might be eligible. You go to a field office and you can find a field office locator online. And now they opened about 2 weeks ago. You can do it online. You can start the application online. And if there's a denial, you can go through the usual process of appealing. So I'm just giving you so that you can see here on the screen the 800 number for Social Security and a link to filing an application. Social Security will tell you now that they prefer that you file online because it's faster. Now, at this point, you can also calculate different scenarios. Social Security has a retirement calculator, and you can see a link here, and you can plug in different numbers. What happens if I retire at age 62? What happens if I retire at age 65 or 67? And you can decide what you will get, and you will also see what your dependents may get. I don't think retirement calculator will show you disabled adult child benefits, a bit too specific. I don't think they're there yet, the agency. You can establish a My Social Security account for yourself and separately for your child. And that is the fastest way to receive basic information from Social Security. Let's say if you need a letter from them to prove as proof of income, you established a My Social Security account for your child, and then you are able to print out a verification of the SSI benefit. If a child is eligible for disabled adult child benefit, you can print out the same way. You can upload information about wages if that's reasonable, if that's appropriate. So Title II or retirement benefit can be received by somebody at full retirement age or early. And I always discourage people on filing at 62, because if you file at 62, your benefit is reduced permanently. So for most people, unfortunately, the way we are, at age 62, most people probably will qualify for a disability benefit. So if you're thinking if I should retire early because work is too much for me, or whatever the other circumstances are, chances are relatively high that you might qualify for a disability benefit. And this way you will receive disability benefit around age 62, and then you can continue receiving it until you reach your full retirement age. And at full retirement age, it will be switched to retirement benefit. If you're entitled to disability benefit, your adult child, disabled child, will be receiving 50% of what you receive. If you are, and if there's any recalculation to your benefit amount, they will be indexing recalculation to the benefit amount of your child at 50%. For most people receiving SSI, when they receive SSI, they receive less in benefits than if they receive disabled adult child benefit. So in other words, receiving half of what their parents receive still may be more than what they are eligible for in SSI. And not just because the federal benefit rate is relatively modest, but also because SSI payment is reduced by different amounts depending on income. To get insured, you have to make at least 1,510 this year, and you can only make 4 credits every year, up to 6,040 this year. And you don't get any credit for work that is not taxable or on which you don't pay taxes for whatever reason. So at full retirement age, Social Security averages your lifetime wages to determine primary insurance amount. So if sometimes you hear PIA, this is what it means, primary insurance amount. So the maximum amount now is $3,345. As you can see, 50% of that is definitely higher than an average SSI benefit that an individual receives. Reduced benefit at age 62, maximum is $2,364. Again, you see the reduction is significant and it stays with you throughout your lifetime. And on the opposite spectrum, if you wait until age 70, the maximum benefit is $4,194. So as a matter of policy, as a matter of law, you can be entitled, you can file an application at age 62. If you didn't file an application, you're not entitled to retirement benefit, which means your child potentially is not entitled to disabled adult child benefit. There is no obligation on your part to file for retirement at an early age, 62. However, once you're at 65 and you file, then Social Security will say, well, did you think about the adult disabled child? Perhaps your child might be eligible on your benefit. There's an annual earnings test. If you file early and at the same time still working, there will be some reduction. So for every $2, $1 will be taken away if you file this year at age 62 and make more than $19,560. If you're filing at the full retirement age and make more than $51,960, again, Social Security will reduce your benefit by one. Every $3 will be reduced by $1. And once you reach the full retirement age, in the year that you reach it and later, there's no annual earnings test. So as far as you are concerned, you can make as much money as you want and you can get benefit and it will have no impact. Your earnings will have no impact on the child's benefit that is received on your record. However, the child's wages, child's work will have an impact. So this is essentially kind of the beginning of how people come into this world. Now, who is entitled? The general rule, you can find, I will even give you the section of the law because this is such a confusing benefit. It is in title of the Code of Federal Regulations. It's Title 20, and the section is 404-350. And this section lists the entitlement rules. So you're entitled to child's benefits on the earnings record of an insured person who is either disabled or retired or passed away. If you are the insured person's child, and that could be child, stepchild, grandchild, child by adoption, if you are dependent on the insured, and a situation of children, in most situations, dependency is assumed, you apply, so there has to be an application filed. Even if your child receives currently SSI, the application has to be filed. You are unmarried, meaning the child is unmarried, and the child is either under age 18 attends school, or if a child is older, but has a disability that started before age 22, this child will be eligible for the disabled adult benefit, DAC. Unfortunately, as you can see, it's not very easy. And there's one condition which I find especially bothersome, and that's marriage. Somebody who is receiving adult child benefit may not stay married and continue entitlement unless the person that they marry to also receive SSDI benefit or retirement benefit. It's kind of a penalty marriage provision that is buried there. Another rule that I would like to caution you about is a rule which is highly unpleasant for somebody who has been collecting SSI benefits, worked a little bit, and now is applying for disabled adult child benefit. The rule here is that disability has to start from before age 22, and it has to be continuous. So if somebody reached wages in a specific amount that Social Security calls substantial gainful activity amount, after certain provisions, sooner or later the benefits will stop, even if the disability doesn't change. It will happen because of wages. And most people who receive SSI, they understand that once they're in their SSI program, you can make fairly decent amount of money and your SSI benefit will slowly be decreased. Essentially, Social Security will count half of your wages to decrease the SSI benefit that you may be eligible for. So you have a situation where somebody is disabled, working and receiving SSI. Parent retired. This individual is filing an application for DAC, for disabled adult child benefit. And in a very surprising way, Social Security is deciding that this person is not entitled because disability was not continuous, because at some point that person made too much money. In other words, reached a point where wages were at the substantial gainful activity amount. This year, hopefully you will all receive table that I forwarded previously, and which is entitled 2022 SSI payment levels in Massachusetts. This table provides different information and different numbers that might be relevant to those who are receiving SSI or SSDI. So this year, substantial gainful activity amount is $1,350 for somebody who's receiving benefits based on disability, and $2,260 for somebody who's receiving benefits based on blindness, legal blindness. As you can see, if you have a child who made that much money at some point, it will not necessarily be a problem on receipt. It will not have a dramatic impact on the SSI receipt. They still will be eligible to some of the SSI money, but it will make them ineligible potentially for DAC benefits. There are some ways that one could mitigate the situation. And if you are facing this dilemma, if you are somebody whose child has been receiving SSI and working, and now there's a potential eligibility for DAC, please get in touch with me. We can talk more. Not everything in wages might be countable. Not every cent in the earnings may be countable. There are ways to decrease the amount which is countable. For example, if the work is a subsidy, if the child works in a special environment, if the child lives in a group home and has a job coach, and then you can mitigate the effect of this harsh rule. But generally, sometimes parents find themselves in a very unexpected situation where they know the disability continues, where they know the child is eligible for SSI, but unfortunately, the CDB or childhood disability benefits are precluded. Well, let's say it's not precluded and you receive it. So what does your child receive? Receives 50% of your PIA, and also after 24 months, receives Medicare coverage. And by the way, the retroactivity period, in other words, if you file an application for CDB, if the parent of the child is disabled, the retroactivity period runs to 12 months. So if I'm filing in May of this year, potential benefits can go back all the way to May of previous year. If a child, a young adult, is filing for CDB benefits and the parent is retired, the retroactivity is only 6 months. It will not go as far. And Medicare will be available after 24 months of benefits, of CDB benefits. And I've seen a question previously, somebody asked, what if I file and receive Medicare? Can this month's of retroactivity coverage be potentially kind of transferred to my child? And the answer is no. The child should get CDB coverage, CDB benefits for 24 months, and then he or she or they will be eligible for Medicare, unless Lou Gehrig's disease is involved, or unfortunately end-stage renal disease is involved. That's an exception so far, and there's a lot of lobbying done to eliminate this waiting period altogether. Another good thing on CDB is that if you file for a disability benefit under Title II as an adult on your own record, benefits are not payable for the first 5 months. It's called a waiting period. If you file as a disabled adult child, benefits are payable right away. There's no waiting period, which is one of the few good sides to the program. Once somebody is eligible for Medicare, you have a wonderful handout. Thank you very much. Very informative. Nicely lays out what's available. Medicare Part A, which is hospital insurance, Medicare Part B, Part D, which is a prescription drug coverage. Part C would be Medicare coverage that you receive through a plan, HMO, ACO, it's managed care plan. Frequently, young adults in this position have already Mass Health. Medicare will become primary insurance. Mass Health will be wraparound insurance. If somebody already has a private insurance plan, unfortunately, if you have Mass Health and now Medicare, Mass Health will not pay your premium assistance. There's an exception for caretaker relatives of children who are disabled under 18, but for young adults with disabilities, there's no premium assistance here, unfortunately. So you kind of have to choose. And some families find themselves in a situation where they're almost overinsured because they're paying premiums for private insurance and they pay Medicare and they're paying now Mass Health. A lot of young adults that we encounter usually have Medicare and Mass Health, especially if they require private duty nursing, PCA, community health service, community services. Mass Health is clearly a more comprehensive type of insurance as compared to Medicare. You have in your handouts referrals to Shine advocates, and I think they probably will be your #1 resource if you're just encountering this question. How, in a variety of plans available to me under all these insurances, do I find the plan that works for my child? And that's a personal decision, primarily several factors that you have to keep in mind. Doctors, do they accept Mass Health? Do they accept Medicare? How do I keep the same doctors? And medications. What medications are covered under what plan? And Shine counselors will be fantastic. And they will be able to help and explain. I'm trying to find 7:05. Okay, I'm just trying to look at the time here. So as far as Mass Health is concerned, another important thing I would like to emphasize, I would like to make before we have questions, is that people in this position, young adults in this position, should not be overly worried about losing Mass Health. Fortunately, we have for adults under age 65, no acid test in Massachusetts. So even if they are now able to save a little bit of money, because if you are in the SSI program, you can't have more than $2,000 in assets. Once you get SSDI, there's no asset limit. Unearned income is not countable. So young adults now not only get more money, but they can save up a little bit and decide what they want to do with the savings. And it will have no impact on Mass Health until they reach age 65, or if they have to be institutionalized. Otherwise, if you live in the community, you can keep Mass Health. Also, if you start working, there's a program, Mass Health Common Health, for disabled working adults. If somebody is disabled, it is exactly the same definition of disability that Social Security has, and works 40 hours per month, not per week, in a very informal setting, doing computer work for a neighbor for $5 an hour is good enough for Mass Health. A person who has too much money, so to speak, to be eligible for Mass Health Standard can be eligible to Mass Health Common Health. So they're not going to lose Mass Health coverage if they wish to do so. So those are the most important points I had to present to you. Let's see if we have questions. I'm applying for SSI for July. I mentioned my daughter is on SSI. How do I apply for her? Oh, for Social Security. So, okay, so we have Margaret, who is applying, I'm assuming, for Social Security for herself. And her daughter is on SSI. So if the daughter is older than 18, if she's a young adult, Margaret will apply for retirement benefit, and the daughter might potentially be eligible for disabled adult child benefit. In this situation, she would have to apply. If she has no legal guardian, she would have to apply for a benefit. If there are some circumstances that make it difficult for her to apply, to sign the application, Social Security is supposed to accept parental signature with explanations. And once this happens, they will have to go back and they will have to see if your daughter worked. If she worked, they will have to see whether her wages ever were higher than the SGA amount for the applicable year. If they were, she may not be eligible. If she never worked, chances are she will be eligible and she will receive 50% of what you receive as a retired person. She will eventually, after 24 months, be eligible for Medicare. Meanwhile, she may continue to be eligible for SSI. And depending on the amount of the childhood disability benefit she gets, she may keep two benefits. However, SSI is reduced dollar for dollar if somebody is receiving childhood disability benefits. So $200 in CDB benefit will reduce SSI benefit by $200. So if you have a high amount of CDB, you may be technically eligible for SSI, but it's not payable because your unearned income is too high. If your CDB benefit is low enough, potentially you may get SSI and CDB. What is the limit to the amount of hours you can work on SSI and SSDI? Thank you. It's a wonderful question. And there is no limit. Social Security is looking, unlike Mass Health, just to keep things interesting for all of us. They have different rules. They're not looking at hours. They're looking at gross monthly wages if you are an employee, or net self-employment income if you engage in your own business. And gross monthly wages in the amount of SGA, substantial gainful activity amount, eventually will preclude eligibility for SSDI. Every year, the SGA amount changes. This year, it's $1,350. If you receive SSI, you can get potentially more. You can get $1,350, or you can get even $2,000. And depending on what else is going on, you may keep a reduced SSI benefit. Why? Because Social Security will count not all of the wages in SSI program, but approximately half of the wages. You know, the actual formula is your wages minus 65, sometimes minus 20 if there's no unearned income, divided by 2. The easy way to remember, if my child was on SSI and works, approximately half of the wages will be countable and reduced SSI amount. If my child on SSDI and works, there's 9 months work period where you can make as much money as possible and still get SSDI. After 9 months, consecutive or not, you're entering another period that Social Security calls extended period of eligibility, EPE, and you can only get benefit if your work is below the SGA amount. If you need more extensive consultation on work incentives for somebody who is on SSI or SSDI, please get in touch with us. Linda Landry, my colleague, and I, this is something what we do, and we have funding from Social Security specifically to spread the word and help people figure out what happens if they work and receive benefits. Okay, so let's see.
So Lana, can I go back to, we did have a few questions that came in before the seminar.
Okay,
I think one of them I know was a lengthy question with scenarios, but it involved the issue of suspending. And I noticed that I think the second question in the chat also asked a question about suspending your own benefit. So I don't know if you want to address that briefly. I know you said it's a very complicated issue.
Right, suspending, the rules on suspending has changed in 2016. I have seen this question and I will respond by email to this person. However, generally, the parent has to be entitled to retirement or disability benefit. And if the retirement or disability benefit stops, DAC stops as well. This is one of the cessation points. Another cessation points for DAC, by the way, is marrying an individual who doesn't receive SSDI. That's really unfortunate. So there's a way to enter a program and then there's a way to not enter. So on suspending, I will email, because depending on what else is going on in the family, suspension might be a good idea or not such a good idea. I would have cautioned if you were thinking about a complicated arrangement where you will suspend something and meanwhile your spouse will receive spousal benefit and suspend something. You have to think about what makes sense for you first, and then think, depending on this PIA, primary insurance amount that I will get, then you file for CDB. The rule in Social Security world, if a young adult is eligible on 2 parental records, potentially, they will take the record with the highest amount in PIA. They will try to get highest PIA, and based on that highest amount, they will pay the child 50%. When suspension is in play, and I'm sure some people on the seminar don't even know what it means, the rules slightly change. So I will set this question aside.
There was also a question in advance about losing premium insurance, which I think you've already addressed, but I will provide you with that. I provided that email to you in advance in case there's anything.
Right, and I looked it up because it is really unfortunate, and I even have a citation for you. Yes, if you are receiving Mass Health and Medicare, with one exception, premium assistance is not available. The exception is in 130 CMR section 502.0020, and this is for caretaker relative of disabled children, but under 18. And another really unpleasant rule in premium assistance is that a disabled individual within the insured group must live with the parent that gets the insurance to get subsidy from Mass Health for private insurance. People who are in group home and other living situations who are not residing with their parents, unfortunately, can't get premium assistance. But the rule for caretaker relative and kids under 18, it's not called premium assistance, it's called Medicare buy-in. It's just another name for it.
Okay, and then there was a question about a adult child or a disabled adult who is in the special enrollment period, is a dual eligible, is in the special enrollment period because of retirement, and is whether dual eligibles can or should consider Medicare Advantage plans designed for dual eligibles.
I would encourage to consider, and then you may decide that it's not something for you. It really is, Shine counselors are the best source for that. And I would also, I wish I could say I wholeheartedly recommend, not anymore, because I think there are some changes in this program, but in Massachusetts, we have another program, One Care, for people who receive Mass Health and Medicare, dually eligible people. And that program is supposed to be consumer driven. You're supposed to have an advocate who will coordinate care for you. And the idea behind this program is funding both from Medicare and Mass Health goes kind of in one pot. And this plan is offering you a variety of benefits. And sometimes you can get benefits that are normally not available under Mass Health and Medicare. So some people really win in this program and some people not so much. Lately, it has been a little bit less user-friendly than before. Why? Because if you're just receiving Mass Health and there's a denial, you can appeal within 30 to 30 days. And by the way, Mass Health is contemplating extending the appeal period. And you go to a board of hearings and you talk to a Mass Health official right away. If you are in OneCare or any kind of managed care plan, you have to first explore the appeal procedures within the plan. And only then you go and file an appeal with Board of Hearings. So it's a little bit more cumbersome, but there's an ombudsman for OneCare. So hopefully any kind of problems may be worked out through the ombudsman program. So the short answer is absolutely explore. Look at what's available because sometimes coverage may be more in these plans.
Okay, so I think that that was what I wanted to get in advance of the chat. So if we return to the chat now, which I've kind of lost my place in.
I think it was Jennifer's next question. Does an application for Medicare have to be filled out for my daughter who is on DAC? She just got DAC 5 months ago. No. After 24 months, Social Security is supposed to send her a Medicare card. It is similar to what's happening to individuals who are receiving SSDI when they just apply on their own record. There's no difference here. So she's still is a ways to go for her, but hopefully she has Mass Health. So now she still has insurance. Right, there's somebody, Deborah. Thank you, Deborah. There is no limit to work. It's calculated by the amount of earnings. Exactly. It's not so much by hours. So if you're lucky enough to get, you know, a $100 an hour job, you can, it will not be about the number of hours they work, but it will be about the substantial gainful activity amount, 1,350. And another word of caution, whenever you interact with Social Security and there is a conversation about work, the general rule is that people are encouraged to work as much as they can. They're not encouraged to work at the substantial gainful activity level. So if somebody is balancing different factors in life and trying to say, okay, does it make sense for me to increase my work? Does it make sense? And then I lose SSDI. Or can I just keep SSDI and stay under the SGA? In conversation with Social Security, I would always encourage to underscore that people are trying to work as much as they can, but based on disability, the realistic idea is that they can only work part-time. They're not designing specifically to stay under SGA, because the legal rule is that if you're capable of working full-time, you should. If you're capable of working many hours, as many hours as possible, you should. But we all know that it's not just a good week or a good day, but it's sustainability. Can you sustain high-paced environment, working many hours, months in and months out, not just on a good day? My son is on SSDI. What is the highest amount he can make each month? 1,350. But as I just said, when you talk to Social Security, the conversation should be at how much he can do based on his capacity, on his disability. If he can't work more than X number of hours because of disability, that's what the conversation should be about. It's not about he can't make more than this amount, because then the question from Social Security would be, well, but can he physically or mentally? If he can, he should. Because remember, Social Security conducts not only work reviews, but they do continuing disability reviews. CDR, which is medical, where they send you a questionnaire with all sorts of questions. And they encourage work, but it's important to point out that if somebody is working, what kind of reasonable accommodations they have. Do they have a flexible work schedule? Do they perform, you know, different tasks as compared to other people? Do they have bad days and they have to miss a lot of work? Do they come, go from place to place, or any kind of special assistance? All of these details, they absolutely have to be included when Social Security conducts medical reviews. Otherwise, there's a danger that SSDI will be cut off because Social Security will decide that there's medical improvement. Do I need to file for retirement if I get SSDI and my daughter is on DAC? Well, Jennifer, if you already receive SSDI yourself at the full retirement age, your SSDI will convert to retirement, to no detriment to you. You will continue to receive the same benefit, probably higher, but it will be called retirement benefit. Another good thing to look forward to at full retirement age is that you, if you can and willing, you will be able to work as much as you can. Because now if you receive SSDI, you are subject to that rule. You can't make more than $1,350. Otherwise, there may be determination that your disability stopped. Once your SSDI switches to retirement, you're no longer subject to any of those rules. Your daughter is receiving DAC, she will continue to receive DAC. And every year, as your PIA amount changes, goes slightly higher, her DAC should also change, go slightly higher, because she's receiving 50% of what you receive. My daughter has been disabled for 4 years psychiatrically, and my ex-husband passed away when my daughter was 15. She's 19. I'm not her legal guardian. Is she eligible to collect SSDI from her dad's passing? Yes, there could be an application provided. Well, she's 19, so she still may be, she would get a survival, a benefit which is not DAC. It will be considered, they will calculate it slightly differently, but she may be receiving a benefit, and this will be called dependence benefit once she is, let's see, at 18. Actually, no, I apologize. If she's 19, she can start, yes, she can apply, and they will figure out what is going on with your husband's record. And if he died insured, and there's a primary insurance amount high enough, she will be eligible to 3/4, 75% of what his PIA would have been. I'm on SSDI. I'm very concerned that the monies will go directly to her as she's not capable to budget. Okay. And by the way, if you're on SSDI, she potentially might be eligible on your record. And in this situation, Social Security has to calculate which record is higher. How is it that she might get more? Now, if you have serious concerns about budgeting, you can apply to become her representative payee. This is not the same as legal guardian. It's very different. Legal guardian has much wider responsibilities and fiduciary duties, but doesn't have necessarily direct control as far as Social Security is concerned over benefits. To have direct control over SSDI or SSI for the daughter, you have to petition and be approved as a representative payee. And then the account will be established in your name for the benefit of your daughter, and that you can manage the benefit for her. And you will have to be then kind of responsible for reporting any significant events to Social Security on your behalf. Contact information at the DLC. I wish I knew by heart the 800 number. 723-8455. This is the general number for DLC, and I apologize, I don't remember the.
We could provide that 800 number with the follow-up email when we send the YouTube link out to folks, and we'll also at the same time send the tables and the link to the slides and the tables. So
okay, excellent. My email, as you see it, if you look in the window where you can see me, you basically see my email, because this is my first name, last name @dlcma.org. But Pam or Chris will be able to forward my email to you, and we can get in touch. My concern is that Medicare does not cover ABA, and Mass Health doesn't cover after age 21. Yeah, that's a big issue, and Medicare definitely not. Perhaps, and I'm not going to volunteer definitive information here. It's just a suggestion because I don't know for sure, but maybe under a waiver, there's a way to cover ABA with Mass Health if she's in one of the waiver programs.
We're at AFAM, we're working really hard. There's a bill pending in the legislature to lift the age cap for ABA and other medically prescribed treatments for autism for those over 21 under Mass Health, in the same way that there's no age cap under ERICA. There was some great progress of that legislation being reported out from the original committee, the Healthcare Committee, but we have to wait and see what happens with it in this session. If it doesn't get passed in this session, it's something that we'll definitely keep fighting for. So.
Yeah, thank you. Yeah, but I completely agree with your strategy. I think if there's any traction, it will be Mass Health. It will not be Medicare. Medicare is administered by CMS, Center for Medicare Services, and it's a giant bureaucracy, kind of looking at the entire United States as a whole, and some states are way behind in healthcare coverage as compared to Massachusetts. So getting anything out of Medicare is probably much more difficult. And by the way, if you are paying out of pocket for ABA, this could be an impairment-related work expense that should reduce countable wages for somebody who is working. So if you have an individual who is receiving ABA, paying out of pocket, and also has wages, let's say, and I apologize now, I have no idea how much it would be, but let's say $300 per month. $300 will be subtracted from wages. So somebody could make more money, above SGA and still remain eligible if Social Security considers ABA payment out of pocket as an impairment-related work expense. Can you use Mass Health to pay Medicare Part B premium? If you are in Mass Health standard and you're income eligible, possible, but a lot of people are not financially eligible for this. It's called Mass Health Standard Premium Assistance. That's the name of the program. I have my daughter on my retired medical, and when she went on SSDI, she lost. Yes, she lost because she. So she probably lost premium assistance based on her income because SSDI is higher than SSI. That would be my guess. Every time there's a reduction in Mass Health benefit, they have to send you a notice. Notice provides you appeal rights. Most of the time, I encourage people to appeal because Mass Health makes mistakes all the time. It's possible that they might have considered something incorrectly because she's still not on Medicare. If she has Mass Health on SSDI, it's possible that they thought that her income is too high, but they might have made a mistake. So I would, if now the appeal period has gone, I would encourage you to call customer service enrollment center or customer service center to verify that they have the correct information. Is the age to retire 62 or 65 being on SSDI? We all have different retirement, full retirement age. It used to be that everybody in the United States who paid FICA taxes was eligible to retire at age 65. Now, slowly, this full retirement age threshold is raised. So for some people, it would be 66. For some people, it would be 67. I know for me, it's 67. So if you're already receiving SSDI, don't worry. Social Security will switch you to retirement at your full retirement age. There will be no reduction at 62. And if you want to look up when your full retirement age on the Social Security website, if you just Google, you will probably go to the Social Security website. They have a calculator, birth dates, and they will give it to you, not just year, but, let's say 66 and 2 months. You will know exactly when is the full retirement age. If I retire before my son's father and my son is receiving SSDI based on my SSA, can he switch to his father's high amount upon his retirement? Yes, he could. Once it happens, they could switch him to the higher PIA. Is $1,350 per month earnings only, or include any SSDI earnings? 1,350, those are wages that somebody is making. So you go to work, and for goods or services produced, you receive your wages. This is 1,350. SSDI is a cash benefit that you will get as a direct deposit to your account. So those are two separate things. So hopefully I answered Morgan's question. If a parent has two disabled children, both collecting SSI, can both children receive this benefit? DAC benefit? Yes. Thank you, Kathy. It's an interesting question. All of us have calculated primary insurance amounts and also primary insurance family maximum amount. In other words, Social Security calculates what is the maximum amount you can receive based on your lifetime wages. And if your dependents, your children would get benefit, what you can get as a family. It's called family maximum. So if one child is already eligible for disabled adult child benefit, and then there's another one who also might be eligible to this benefit, they will both get the benefit. But if their benefit combined is more than you can get in the family maximum, then both benefits will be proportionally reduced to reach that family maximum. So in other words, if your family maximum, let's say $5,000, and two children receive benefit, and if I count your benefit, a benefit for child number one, a benefit for child number two, and all of this three combined benefits is more than 5,000, benefits for the children will be reduced so that totally you only get 5,000. And please keep in mind that this is only an example. Each one of us has different numbers, different primary insurance amounts. It depends on the wages that we had over lifetime. Once my daughter gets Medicare, do I have to let Mass Health Standard know? Or is this automatic and she will still get both? You have to let them know. They're supposed to conduct reviews and send you updates, and you have an obligation to report relevant events to Mass Health. So you have to let them know. Mass Health seems to be counting SSDI income against the maximum income limit for eligibility for Mass Health Standard. We were told that now that our son gets SSDI income, he's over the threshold. Unfortunately, yes, that could be the case. And when the COVID-related moratorium and eligibility reevaluation is lifted, he will have to go on Common Health instead of Standard and pay a premium. Yes, this is a correct determination, Phil. I'm sorry, unfortunately, that's true. I guess the good side to it is that it will not be that difficult to establish Common Health eligibility. If there are two ways. You can say that your son is a disabled adult individual who's working. And remember, work can be informal. It doesn't have to be for a corporation, for a particular business. It could be for a neighbor. It could be for a friend, even within the family. Mass Health is quite informal, at least now, when they review what they consider work. Or they will send you a specific calculation, and it will be called a one-time Mass Health deductible. And what it is an amount, it's individual, they calculate it. Usually it's around, well, it used to be, and I apologize, I haven't seen those calculations in a while, but it used to be, it was around 2,000. And you have to you have to incur medical expenses in the amount that Social Security calculates. And please remember, you have to incur expenses, not necessarily pay the expenses. So if your son receives Mass Health notice where they say you have two ways to enter a Common Health program, either as a disabled adult working child or working individual, or here's your one-time amount that you have to meet, you can submit bills for medical services that are incurred in that amount, and Social Security will not cover those bills, but they will count it in lieu of the meeting the deductible. And then you can negotiate with medical providers. Maybe you can pay less, maybe you can have payment plans. You don't have to necessarily pay everything right away, but yes, you have to pay out of pocket. That's another way to get into this program, and you do it only once. It's a one-time deductible. For individuals, by the way, over age 65, they have to do this every 6 months. It becomes very difficult. So we are at 7:36. And I think.
You've done a wonderful job of answering people's questions. I think that's all the questions that were in the chat.
Okay.
Yeah.
Let's see.
And I do want to stress that we will send out, I'm saying we, and we have Pam McKillop to thank for this and the Autism Alliance, will send out to everyone who registered the slides, a link to the YouTube recording, and then also a couple of tables that we've been provided that we haven't put up tonight, but you'll be able to see those tables as well. So I want to thank you so much, Svetlana, for a wonderful presentation. And I know I'm going to go back to it many times as I work through this transition myself. And again, I want to thank Helen Golding for preparing an incredible fact sheet, which people really should, you should have received it. If for some reason you haven't, email us, but it came to you with the link for the Zoom. It has great resources at the end with links to, for example, Shine counselors. So make sure you hold on to that. And so thank you, Helen, and the Autism Insurance Center. And Pam, thank you so much for being my best Zoom friend ever. So,
you're welcome.
Yeah. Thanks everybody for your time. And I hope this has been helpful to you. And
thank you. And I apologize. In conclusion, I forgot to mention it. Tomorrow, the slides that you received, this is for presentation tomorrow for elder benefits all-day seminar. If you have time or if you are interested, it's Mass Continuing Legal Education. They will run an all-day seminar all about elder benefits. So if you're interested for yourself, you can register and you don't have to be sitting in front of the computer for the entire day. Once you register, the program is available as a recorded program and you can look at different pieces at your leisure. And a wonderful team of really experienced attorneys joining me for this program, and they will be talking in depth about Medicare and Mass Health for elders.